Welcome to People's Law School. My name is Charles Brinkley, and tonight I have the privilege of introducing Connie Glass. Connie Glass is the preeminent elder lawyer in the state of Alabama, and her firm is the Elder Law Firm. She is one of only 4 certified elder lawyers in the state of Alabama. She has over 25 years of experience in the field of elder law, and prior to opening the elder law firm, she served as the attorney for the TARCOG, I hope I'm pronouncing that right, area agency on aging for over 10 years and was on the staff of the University of Alabama Law School. She graduated from the University of Alabama and she got her law degree from the University of Alabama. She's also a charter member of the Alabama State Bar Elder Law Section. She is also a member of the National Academy of Elder Law Attorneys, the National Elder Law Foundation, and the Alabama Guardianship Association. Everybody here should be interested in this tonight, unless they somehow find the fountain of youth, because everybody's going to have either themselves or a loved one, a grandparent, father that is going to need the help of an elder lawyer. So please welcome Connie Glass.
Good evening. Thank you, Charles. I appreciate that introduction. Elder law, that's what we're going to talk about tonight. So hopefully you've got a lot of good questions and hopefully you'll learn a lot about the topic of elder law. Elder law is one of the few areas of law that focuses on a group of people. It's not a subject matter like bankruptcy or criminal law. It's a group of people as they age need elder law attorneys. And hopefully tonight you'll get the information about why that is. I want to talk about, kind of hit on the topics that most elder law attorneys cover. I want to talk a little bit about the settings for long-term care, how we pay for long-term care, particularly the Medicaid program, Medicaid benefits. I want to talk a little bit about the documents you need for estate planning, probate, and then guardianship and conservatorship. So hopefully we'll be able to cover all of those things. So we're going to move quickly. It's a lot of information. If you do have a question that you think pertains to what we're talking about at the moment, if you will just get my attention, I will repeat your question and try to answer it for you briefly so that we can get in everything we want to talk about tonight. All right, let's start out by talking a little bit about long-term care and the settings that you can in which you can receive long-term care. Obviously, long-term care is just what it says. It is care that you're going to need over a long-term basis. It's not care where you go to the hospital, you get better, you come home, and you get back to your life. This is care generally from some sort of chronic illness or chronic condition that's going to last probably for the rest of your life that necessitates that you receive some sort of care, whether that be in-home care or in a facility. Neither Medicare nor Medicaid pays for some of these settings, and I'm going to try to define each one and where Medicare and Medicaid will cover care in the facilities. Won't spend a lot of time on in-home care. Obviously, you understand what that is. You hire people to come into your home. Assisted living facilities. Let's talk a little bit about assisted living facilities. In Alabama, we have facilities that are not nursing homes, but they're designed to provide assistance with activities of daily living. We have 2 types of assisted living facilities in Alabama. For lack of a better word, I call them regular assisted livings and then what we call specialty care assisted living facilities. Specialty care is the newer of the 2 types of facilities, and those kinds of facilities provide care to people with cognitive impairment. Alzheimer's, stroke-related dementia, vascular dementia, any sort of cognitive issue, those folks can get care in a specialty care assisted living. Specialty care assisted living, just a little bit different than regular in that the staffing levels are a little higher. Most of those facilities are secure facilities because wandering sometimes comes with cognitive impairment. The next level of care is nursing home care. That's a facility in which you receive nursing care. It's a different level of care than you can receive in an assisted living facility. There are private nursing homes, and then in Alabama we have 4 veterans nursing homes. We have the newest one that we have in Alabama is located in Pell City. The veterans nursing homes are in Bay Minette, Alexander City, Huntsville, and Pell City, with Pell City being the newest one. Most of the veterans nursing homes do have a waiting list, but they provide care for veterans of any armed forces, and you do not have to have served in a war period, or nor do you have to be a disabled veteran in order to enter a veterans nursing home. All right, that's the types of facilities and the types of places you can receive care. How are you going to pay for that? How do you pay for assisted living, specialty care assisted living nursing homes or veterans nursing homes? Well, jumping from in-home care, which can be the most expensive kind of care you can get if you do it round the clock 24 hours a day, that can run as much as $15,000, $18,000 a month. Assisted living care can be, usually runs anywhere from $3,000 to $5,000 and upwards. Specialty care assisted living is on the upper end of that. And then nursing home care in the North Alabama area averages about $6,000 a month. So you can see that not a lot of people have the ability just to write checks for that kind of care for a long period of time. So how are you going to pay for that? One of the sources of payment for facility care is long-term care insurance. If you qualify for long-term care insurance, you can purchase insurance that will cover that need that you have in the future. Now, obviously, you can't get long-term care insurance after you already need the care. So if you already have a diagnosis of Alzheimer's, or if you've already had a stroke, you're not going to be able to get long-term care insurance to cover that need. But if you're relatively healthy, generally I suggest over the age of 50 to 55, then long-term care insurance is something that you might want to consider purchasing. Age and health are the two biggest factors in determining what the premiums for long-term care insurance will be. Obviously, the younger you are, the lower the premium. The healthier you are, the lower the premium. And then you have to look, the next decider on the premium is the kind of coverage you're going to get. Are you going to buy 3 years worth of coverage or 5 years worth of coverage? Or are you going to buy lifetime coverage, which is obviously the most expensive kind of care? If you don't have long-term care insurance, then you have to look at other sources of payment. Medicare benefits. Medicare does not cover any kind of care in assisted living nor specialty care assisted living. The facilities such as assisted livings or specialty care assisted livings, those are private pay. So either you're going to be writing the check yourself, somebody's going to be writing the check out of their funds, or you have long-term care insurance that's going to cover that care. Yes, sir?
Could I go back to the time elements that you mentioned?
Yes.
What is the average amount of time that a person spends in the assisted living?
The question is, what is the average amount of time a person spends in assisted living? That's a very difficult question to answer, basically because there's not a lot of studies about assisted living care. They're not as highly regulated and monitored as nursing homes. So there aren't a lot of statistics for that number. In my practice, a lot of people can stay in assisted living care for their entire life, particularly if they remain mobile and their need might just be the cognitive issues, the Alzheimer's, some type of dementia, but physically they're relatively healthy. They can get up, they can go to the dining room, they can, dress themselves with some help, they can bathe with some help. Sometimes those folks can live in assisted living, 5 to 10 years.
I've heard that there was an average of something like 4 years. My question is really leading towards, what would you suggest that a person consider when they're buying the insurance?
The question is, what do I suggest when you're looking at long-term care insurance? I suggest 5 years, and I'll tell you why in just a minute when we're talking about Medicaid. I don't suggest the unlimited policies, the lifetime policies, just because they're cost prohibitive for most people. But obviously that's the best if you can afford it to buy care for the rest of your life. Yes, sir?
There is an average nursing home stay. It's about 2.4 years.
2.5 years.
But that's like saying the average temperature of Huntsville is 70 degrees.
Exactly.
A lot of variation.
Right. That's a very excellent point. The average length of stay in a nursing home is about 2.5 years. Now, I have had clients stay in nursing homes for 6 months. I've had clients stay in there for 12 years. So that average is a little bit deceiving type of average because there are a lot of people that go into nursing homes that don't stay more than 30 days, 60 days, 90 days. They're in there for rehabilitation. My mom stayed in nursing homes about 4 times during her lifetime, but never more than about 90 days at the most, because she was rehabilitating after either a fall or surgery of some sort. So she was never in a facility long term. So again, those average numbers are a little bit deceiving. Okay, and I will answer that question, why I recommend 5 years. Medicare benefits. Medicare pays for skilled nursing facilities, but very short term. Medicare pays for the first 20 days if you enter a nursing home after you've been in the hospital for at least 3 days and you're admitted to the nursing home for the same condition for which you entered the hospital and were treated in the hospital. And Medicare, you can get approved for up to 100 days of Medicare. Medicare only pays fully for the first 20. Then from days 21 through 100, there's a $152 a day copayment. A lot of Medicare supplement insurances don't cover that copayment. So after 20 days, most people have to start paying the $152 a day in copayments. And then after 100 days, if you're approved for that 100 days, then you move over into long-term care, which on the average in this area is about $200 a day. So you can't count on Medicare benefits for extended stays in the nursing home. It's just not available. That's not what Medicare is for. Medicare's health insurance. It's for acute care. It's for short-term stays in the hospital, short-term stays in a nursing home, rehabilitation for short-term. So it's not to provide you with long-term care benefits in the nursing home. That leads us to Medicaid. Medicaid is a needs-based government insurance program. It's a partially federally funded and partially funded by the states. And in Alabama, almost 3/4 of all nursing home patients are on Medicaid. I know, startling statistic, right? Now, these people are not poor people who enter nursing homes. Some of them don't have a lot of means when they enter, but most of them are just like us. They're regular folks who enter nursing homes. They exhaust their resources and have to apply for Medicaid assistance. So 3/4 of all nursing home patients, almost 3/4, are on Medicaid benefits in Alabama nursing homes. So you can see that Alabama nursing homes really can't function without the Medicaid program because of the extraordinarily large number of dollars that they receive from Medicaid. Medicaid is jointly funded by the federal government and the state government. Most of our dollars come from the federal government. It is also a state-administered program under a certain body of federal law. What that means for you as the consumer is that Medicaid is different from state to state. Tennessee long-term Medicaid is different from Alabama long-term Medicaid, which is different from Florida's long-term care Medicaid program. So you could be eligible in one state, but not eligible in another if you moved from one nursing home to another nursing home in different states. And I've had that happen. I had a client very recently whose aunt was eligible for Medicaid in Florida, but not eligible for Medicaid in Alabama. Question in the back. Let me get his first.
Any commentary on Governor Bentley's not allowing federal Medicaid dollars to come in?
The question is, do I have any commentary on Governor Bentley not allowing the expansion of Medicaid? Has nothing to do with elder law. So I have a personal opinion on it, which I probably don't need to share with y'all tonight. But it doesn't. That is not the Medicaid program that this is. The Medicaid program that I'm talking about is a fully funded operating Medicaid program that we've had for many, many years. Question.
In Alabama, what percent is provided by the federal government, what percent is provided?
I knew you were going to ask me that. I think it's 4-to-1. Every $4, for every $5, I'm sorry, I needed to repeat your question. What is the percentage of dollars that the federal government gives as opposed to the Alabama dollars? I believe it's 4-to-1. Don't hold me to that, but I believe that's right.
What is your personal opinion regarding the
Expansion of Medicaid, my personal opinion, Alan's going to put me on the spot and make me tell you what my personal opinion is.
The lawyers don't mince words, this is real time.
Yeah. I think it's a travesty that we've not expanded our Medicaid program in the state of Alabama. That insurance is for the working poor. The expansion would be for those people who are in minimum wage jobs who don't have ability to get insurance any other way. It's not offered by their employer. They can't afford it. They're making minimum wage. They can't pay premiums for medical insurance. So the only way that these folks can afford medical insurance is the expansion of the Medicaid program. So that's my personal opinion.
Going back to your mother's example
Yes.
with your mother, she was in and out of the, using Medicare and.
Medicaid.
She
I'm
used
sorry, Medicare, you're exactly right, I'm sorry.
I'm changing
My mom
subject.
did use Medicare benefits
I'm
in
changing
nursing home.
subject on you here, back to Medicare. Now, did she, in other words, you said that you have a period of time for Medicare of 100
Yeah,
days.
I know where you're headed with
Going in
this,
and
yeah.
out, is it repeatable that you can do it?
Yeah, the question is, for example, using my mom, who did pass away 3 years ago, Mom's Medicare benefit, she got the 100 days of Medicare each time she was in the facility because once you have a 60-day break, let's say you're in the nursing home for rehabilitation for 100 days, and then you're able to go home and you stay at home 2 or 3 months. As long as there's a 60-day break, then if you go back in the hospital for 3 days, back in the nursing home, then Medicare will pay again. And you can do that several times within a year. It's not a yearly benefit, it's a per illness benefit. And the key there is a 60-day break from the time you're discharged from the nursing home until the time you re-enter a hospital. So as long as there's a 60-day break, you can go back in under Medicare.
For the same problem.
Yeah, yes, it could be for the same problem. Okay, let me run through Medicaid real quickly because this is kind of the meat of what everybody always wants to know about. Tell me about Medicaid benefits. I answer these questions all day long, every day. So you're getting the answers free of charge tonight. So kind of free of charge tonight. So let me tell you a little bit about Medicaid. There are two tests you have to meet financially to qualify for Medicaid benefits in a nursing home. The first test is an income test. Alabama is what's called an income cap state. We have an income cap, so if your income is above that dollar level of the income cap, then you don't qualify for Medicaid in the nursing home without doing something extra to qualify. The income cap in Alabama, it's on page 5 of your outline, is $2,163 a month. So if you have income of $2,200 a month, then you don't qualify for Medicaid for the nursing home, okay? What do? $2,200 won't pay your $6,000 nursing home bill, so if you don't qualify because of your income, what do? Many years ago, since I've been practicing, the federal government created something called the Qualified Income Trust. It is not a trust that you would think of in any traditional form of the word trust. It's a conduit for your income. So if your income is over this $2,163 and you're in the nursing home and you're ready to qualify for Medicaid, the only thing that's keeping you from qualifying for Medicaid is your income. Then you can come to somebody like me or somebody who knows how to do income trusts, and the attorney will draft you a trust. Your trustee will take that trust down to a bank and they're going to open up a new bank account. And there's only one thing that's going in that bank account, your income. When your income goes into that bank account, then you don't have control of it anymore because it's in a trust account. So the minute it goes in that income trust account, it's not available to you anymore because it's under the control of the trustee in the trust account. So voila, you qualify for Medicaid magically. You're income eligible. Now, what happens to that money in the trust account? It pays to the nursing home just like it would if there was no income trust account. So it's just an artificial way to make you meet the income eligibility limit. That's all it is. That's all it's used for. You don't need to do it now. You can't do it in advance. You don't want to put your income in this trust in advance. We generally set it up the month before we're going to qualify for Medicaid. So if we're applying for March, we would have set up the income trust in February. If we're applying in April, we'll set it up in March. So it's not something you want to do ahead of time, but just keep it in mind if your income is over that income limit.
You have to put all the income in.
The question is, do you have to put all of the income in? Technically, no, but it's too big a management issue if you don't. So generally, what we suggest to our clients is all of the income go in, then you only have one place to manage that income, and then that income goes out to the nursing home.
Does that include interest income?
You're not going to have any interest. The question is, does that include interest income? You're not going to have any interest income because all your assets are going to be spent down to $2,000. $2,000 doesn't draw any interest in a checking account. So that's the other part of the test, is the resource test, and let's talk about that real quickly. Was that your question too?
Well, I was going to ask about annuities. That's considered income, right?
The question about annuities, if it is an annuity, just a check each month, yes, it is income. If it's an annuity that you purchased that has a dollar amount value, that's an asset. It is income too, but it's also an asset. So we'll talk about that in just a second. Yes, ma'am.
The trust, you have no personal access to it for personal purposes at all.
The question is, in the income trust, does the nursing home resident have any personal access to it? The nursing home resident's name cannot be a signer on the account. And if you're in a nursing home on Medicaid, you don't have access to your personal income anyway. You get to keep $30 a month for your personal needs, and that's all you get to keep. So the rest of your income has to go to the nursing home to pay for your care, and then Medicaid picks up the difference. Okay, income is a fixable problem, so nobody's income should be a barrier to them qualifying for Medicaid. What is the barrier? It's the resource test, the asset test. There's two sets of rules. Well, there's actually three sets of rules. There's the single person rules. There's the married couple rules when one spouse is not in a nursing home. And then there's the married couple rules when both spouses are in the nursing home. So you got three potential sets of rules that may apply to your situation. Single people, it's about as simple as Medicaid gets. All of your assets that can be converted to cash have to be converted to cash and spent down to a level of $2,000 before you can qualify for Medicaid. So that's your CDs, your stocks, your bonds, your mutual funds, your IRAs, your annuities that can be cashed in, your savings bonds, your timeshare, anything that you own that can be converted to cash must be converted to cash, and you must pay that. Now, what is spend down? You don't give it to anybody. You're writing a check each month to pay for your care in the nursing home. That's spend down. So if you've got a CD in the bank that's worth $100,000 and you go to the nursing home, somebody in your life is going to cash that CD in, put it in your checking account, and they're going to write a check to the nursing home for $6,000 every month until it's gone. At which point then, if that's all you had, then they apply for Medicaid. Okay? So you don't give those assets to anybody. That's kind of a common misconception, that when you go to a nursing home that you hand over your assets to the nursing home. That's not what happens. Your assets stay just as they are. They stay in the bank, they stay in the form that they're in, and you simply write a check each month to the nursing home. What if you don't write that check? Then the nursing home doesn't have to keep you. You have to pay for your stay there. Okay?
How long do you have to convert real estate to cash?
Question is, how long do you have to convert real estate to cash? That's an excellent question. Let's say that I go to the nursing home and I have a house and it's sitting in, there's nobody living in it, and I go to the nursing home. There's a couple of things I can do about my house. I can tell the people at Medicaid, well, I'm going to go back to that house. I have every intent to get better and go home. If I have an intent to return, then Medicaid won't make me sell it at that point because I'm intending to return to it. But once I apply for Medicaid and I'm approved for Medicaid, then Medicaid's going to take a lien against that property for every dollar that they pay out for my care. Now, if I'm able to go home and live in my home, then that lien goes away. But if I stay in the nursing home and I pass away in the nursing home, then at my death, Medicaid expects to get paid back from the sale of that house from my estate. So that's one thing that can happen with the house, the intent to return. Let's say that you've exhausted all of your money and you've got your house listed for sale, but it's not selling. It's in an area maybe it's not selling well, or it needs a lot of work and nobody's made an offer on it. Then as long as you have it listed for sale and you can prove that to Medicaid, then Medicaid can go ahead and approve you for benefits. Again, they'll take a lien. So at the point that the property does sell, they will get paid back dollar for dollar of what they've paid out for your care. Now, let's say that you have a $100,000 house and Medicaid's paid out $200,000 by the time the house sells. What do they get? They'll get everything. They get the entire proceeds. Who has to pay them back the balance? Nobody. They just have to eat that. Because all they can get back is the value of the home. They can't get, they're not going to go to your family members and say, well, we've paid out $200,000, where's the other 100? So Medicaid has a dollar for dollar lien of what they've paid out up to the value of the home. Okay?
How long does the lien stay on the house?
Question is, how long does the lien stay on the house? Forever, unless you return to it. I mean, there are properties all over the state of Alabama that have Medicaid liens on them that are just,
About 20 years before they sell it, and Medicaid don't,
yeah, Medicaid has a recorded lien.
they never check it. I don't think they sold it.
I've never had that happen to any of my clients. So let's see. His point was that he's had known of people who've had Medicaid liens and Medicaid didn't collect them because it took so long to sell the house. I've never known of that occurring, but I'm not going to say it doesn't happen. You have a question?
Let's say that you put that property in a child, one of your children's names or your sister's name or what have you. How far can Medicaid go back?
It's 5 years, and I'm going to talk about that in just a second. The look-back period is 5 years, about looking back on transfers.
What
Yes.
if there are multiple owners? Many owners of that property.
The question is, what if there are multiple owners of a piece of property? Let's say that you own a piece of property with 20 nieces and nephews of your grandparents. Medicaid will have a lien against your share of that property. So if you have a 1/20th interest, Medicaid has a lien for 1/20th. If you have a 1/4, Medicaid has a lien for 1/4. So whatever your interest is all that Medicaid can attach. They can't attach property that you don't own. Yes, ma'am.
What types of cases do you deal with as a lawyer?
What type
Is
of,
it mainly about Medicaid?
the question is what type of cases I deal with as an elder law attorney. Everything that I'm talking about tonight, in various shape, form, and fashion, I've dealt with over the last 25 years, 27 years.
Will it be nursing homes that are your clients, or?
No, ma'am. The question is, are nursing homes my clients? No, it's nursing home residents and their families who are my clients. And again, I do this anywhere from the pre-planning where people are healthy and they come in and they want to talk about what do I need to do to get ready, or mother had a stroke and went to the nursing home yesterday, what do we do? Or mom's been in the nursing home 3 years, we're running out of money, how do we get on Medicaid? Anywhere in between those are what we deal with on a daily basis. There are certain things that are exempt. A nursing home resident can have a car, they can have some burial funds, their burial space items, their casket, the vault, opening and closing the grave, the plot and the marker, can have that. Their household goods and personal effects, Medicaid doesn't have the manpower to go out and inventory what's in somebody's house or their nursing home room, so your personal things are exempt. But generally everything else that can be converted to cash is countable. Just a little bit about married couples. Want to just briefly go over those rules. Remember I told you there were 2 sets of rules that apply to married people. If one of a married couple goes into the nursing home, then there are a certain number of assets that are going to be protected or set aside for the spouse at home, what we call in Medicaid parlance the community spouse, the spouse that's still out in the community. In your handout, it's on page 7 and 8 of your handout, when one of a married couple enters the nursing home, Medicaid does what they call a snapshot. They look at all of the assets that either one of them owns. It doesn't matter whose name it's in. And then a certain amount of those assets are exempt or excluded assets. The home, as long as the spouse is living there, it's totally excluded. No lien. Medicaid just acts like it doesn't exist. A vehicle, the things inside the house, the burial funds, all of those things are exempt. Everything else that the couple owns is added up. And there's a formula that Medicaid loves formulas. There's a formula that Medicaid uses to determine how much the spouse at home, the community spouse, is going to get to keep, and how much the spouse in the nursing home will have to spend. The community spouse, the one at home, is allowed to keep the greater of $25,000 or 1/2 of the assets, not up to a maximum of $117,240, $117,240. Okay? Now that's just clear as mud, I'm sure. These strange numbers, I know, they're odd numbers, and I have to keep up with them. I have to keep them in my head. The countable assets, now don't include those that I said were excluded, the house, the car, the burial funds, those don't figure into these numbers. So let me just kind of give you some hard numbers. Let's say you have a married couple, they have a house, a car, and $100,000 in the bank. So the spouse at home will get to keep the house, the car, the personal things, and 50 of the $100,000, half. All right, let's say that they have $300,000. So half would be 150. Can't keep 150. Remember I told you there was a maximum, 117,240. And I can't do that math in my head. The spouse of the nursing home has to spend everything between 117,240 and the 300. So the spouse in the nursing home has to spend more than half because of this number. Now, if they only have $30,000 in the bank, the spouse at home is going to get to keep 25 of it because that's the minimum protected amount. So there's a minimum protected and a maximum protected. And usually it falls somewhere in between. So the take home for this is, can you see that there's no way on earth that you could tell any married person what you're going to get to keep if you have to go, if your spouse has to go to the nursing home? Because every couple in this room and every one of us who are married are going to get to keep a different number of dollars because it depends on what you start with. So unless you have the exact same number of dollars that your neighbor does, it doesn't matter what your neighbor got to keep. It's going to be different than what you get to keep because it's set by what you have when one of you enters the nursing home.
Under Medicaid.
Under Medicaid, that's right. All right, the third set of rules, the married couple that both are in a facility, both are in a nursing home. They are then treated as individuals. Although they're married, Medicaid looks at them as two separate people for determining eligibility. So then, and only then, does it matter whose name the asset is in. Because if the couple has $100,000, but $80,000 of it's in the husband's name, and they're both in the nursing home, then he has to spend 80, and she'll have to spend the other 20 that's in her name. So that's the only occasion when it matters which spouse owns what, because they're treated as individuals. All right? Everybody with me on that? Just a little peculiarity in the spousal rules. So what happens a lot of times is I have clients who help get the spouse in the nursing home on Medicaid, and then 6 months from now, the wife breaks her hip and she's about to go to the nursing home. So we've got to look at eligibility for her based on the assets that were protected for her. And that might mean now the house is going to become countable. It was excluded as long as she lived there. But now that she can't live there anymore, it's going to become countable. Okay? All right, here's the big question, transfer of assets. And this will answer your question and your question about long-term care insurance. When you apply for Medicaid, there's a question on the application that says, have you given away or transferred anything for less than its value in the last 60 months? That is called the look-back period. If you apply for Medicaid, Medicaid has the right to look back in your finances for 5 years. If you have given away or sold something or transferred something for less than it's worth, then Medicaid adds up all of those transfers or gifts. They divide that number by the average cost of care in Alabama, and they come up with a number of months that you will not be eligible for Medicaid. However long that thing that you gave away would have lasted you in the nursing home is how long Medicaid won't pay. So mom goes to the nursing home, she spends everything she has, she's down to $2,000, her income's below the limit, she applies for Medicaid. Medicaid looks back in her financial history, and 2 years ago, she gave her grandson $10,000, $12,000 to go to college. Medicaid looks and says, aha, you gave your grandson $12,000 2 years ago. We're not going to pay for your care for 2 months. How does mom pay for her care? Hopefully her family is nice and will write a check to the nursing home because Medicaid won't pay it. Question?
So there's a set amount of money that the state says is the average nursing home cost. You can't use the cost of the home that the person's in.
That the question is, does Medicaid have a set amount? This year, a set amount that they divide by. This year it's $5,500. That changes a little bit every year.
My aunt gave her son, he was living with her at the time she was sick and went into the, and she gave him the house, signed it over to him. And then Medicaid apparently, now this was in Florida, so it may be a different rule.
Different rules, don't
And
confuse everybody.
They forced him to sell the house, and he had to move out.
Okay, Medicaid cannot force anybody to do anything except the nursing home resident. Let's say that I give my house to my daughter, and 2 years from now I go to the nursing home and I don't have the money to pay the bill and I apply for Medicaid. Can they make my daughter give it back? Absolutely not. She's not applying for Medicaid. She's not under the purvey of Medicaid's rules. All they can do is deny me benefits. They can assess a penalty for me. Medicaid has no ability to make the person who received the gift give anything back. Okay? Does that make sense?
Isn't there a gift tax, though, if you did that?
Gift tax really only applies to people with taxable estates, and the estate tax limit right now is $5.37 million, so I dare say that most of us are under that limit. Okay?
What about if a house is deeded over while a person is in having cognitive problems?
The question is, what if the property is deeded and the person is having cognitive issues? Well, if the person signed a deed and they didn't have the capacity to sign it, then that deed is subject to challenge in the court. If somebody used a power of attorney to deed the property, it just depends on whether they had the power to deed it. So, yeah, I'm not sure exactly.
The person that's in the nursing home, let's say they deeded the property before they went to the nursing home. They went to the nursing home for dementia, and the dementia was present before this deed was actually deeded over.
Question is, what if a person has dementia and deeds away their property? A diagnosis of dementia doesn't prevent somebody from conducting business if they have the legal capacity to do so. I represent a lot of people that have dementia that have legal capacity to do legal documents. So it really depends on whether the person had the capacity to make the request that the document be drafted and they understood what they were doing when they signed it.
What if Granny goes down to the casinos and loses $10,000 playing Texas Hold'em?
That's a great question. What if Granny goes to the casino and loses $10,000? What does Medicaid do with that? We had that very issue. It wasn't Granny, it was Grandpa. But he took out every weekend that he went to the casinos, which was usually 2 to 3 times in a month, $5,000 when he went. We proved that. We had his hotel records from the casino. Now, we couldn't prove that he spent it in the casino, but by golly, he went to the casinos once or twice or 3 times a month, and he took out $5,000 every time he went, and he didn't come back with it. So logic will tell you that that's where he spent it, and Medicaid did accept our argument that he spent it. He has a right to spend it in the casino. Can't give it to his grandson, but he has a right to spend it at the casino. Okay, let me answer your question about, I think I answered your question about the look-back period, the 5-year look-back period. Now, the penalty is not 5 years. The penalty is however long that money would have lasted you in the nursing home. The look-back period is how long Medicaid looks back, which I think answers your question about why I recommend 5 years' worth of long-term care insurance, for that very reason. If you want to transfer assets, you need 5 years' worth of coverage to get you through that 5-year look-back period. So that's why I recommend 5 years. Question in the middle.
Regarding the property ownership, could you touch on any difference if the property is owned in life estate? For example, if a child deeds property to his parents in life estate, What does Medicaid do with?
It's an excellent question. The question is about life estate deeds. How does Medicaid look at a life estate deed? A life estate is not accountable interest in property. So if the only interest I own in my property is a life estate, and you're looking at me like, well, what is that? A life estate is I have the right to use that property, the control and use of that property during my lifetime. And then at my death, it will automatically go to whomever I have designated as the remainderman. So I've really deeded my property away. It's a split title. I've deeded my property to somebody else, but reserve the right to live on it for the rest of my life. A lot of older people do that. Now, how does Medicaid look at that? Medicaid does not count the life estate as having any value. However, when you deed the property away, that's when the transfer happens. So if I give my property to my daughter and reserve a life estate, the month in which I signed that deed, deeding it to her, reserving the right for me to live there, I have transferred the value of my property. So that transfer will follow me for the next 60 months, 5 years. So it's not the life estate that's your problem, it's the transfer of the property that's the problem. Question?
Yes, reverse mortgages, does that come under your expertise?
I do advise clients about reverse mortgages. The main use of reverse mortgages is for people to be able to tap into the equity of their home when they don't have other cash resources. If I've got a client who wants to stay at home and they want to hire in-home care and they have no money to speak of, they can get a reverse mortgage to tap into the equity of the home to pay for that in-home care. That's if you still have any of those. How does Medicaid look at reverse mortgage? If you have the dollars, they're countable as an asset. If you've borrowed against your home and you got $40,000 sitting in the bank, that's a countable asset. $40,000. Yes.
You discussed giving the family, giving the home to the child or whatever, giving the home away.
Mm-hmm.
Do you give the tax advice as well? Because the basis of the property goes with it as long as a person's living.
Not necessarily, not when they reserve a life estate. I am not an accountant. I do not have an LLM in taxation. I give only the very most basic tax advice, and if you have tax advice that you need other than the very basic that I can answer, then you need to talk to your accountant. And if you talk to an accountant, 4 accountants about life estate deeds, you're going to get 3.5 different answers. So that's not a settled question in the law. Okay, I want to shift gears and talk just real quickly about probate, when you need to probate, and kind of the documents you need. I recommend that every client get a will, durable power of attorney for finances, a durable power of attorney for health care, and a living will. Those are the 4 basic documents. You may need more than that. You may need something more involved than that. But everybody sitting here in this room and listening to my voice needs to get those basic documents. Without those, you've missed a component of your estate plan. You may have a will, but that's only going to distribute your assets at your death. What if you become disabled or incapacitated and can't manage your affairs, and you're in the hospital unconscious? Who's going to take care of things for you? Who's going to authorize surgery if you're not able to do that? Who's going to make the end-of-life decisions for you if you're not able to make those for yourself? Have you put that in writing as to what you want done? So those 4 basic documents are what you need. Yes, they're in your handout. A will, a durable power of attorney for finances, a durable power of attorney for health care, and the advance directive for health care, which most of you know is the living will. The only one of those that I suggest that you use a form for would be the living will. If you have everything else and you only are missing that component of the advance directive for health care, you can actually get that form online through the Alabama State Bar. You can pick one up at the hospital. But for the other documents, I would recommend getting off your pocketbook a little bit and going to a lawyer and paying for the advice that you're going to get in preparing those documents. I am not a proponent of using the internet to prepare documents that are going to go into effect when you're unconscious in the hospital.
Is that part of what you do?
I absolutely do documents for folks. One of the things that clients ask me all the time was, I printed this form off the internet, can I just use it? Well, here's my answer, and it's a little bit facetious, but not really. You can also print off directions to remove your gallbladder. but you probably don't want to do that either. So that's kind of the way I feel about internet forms for doing legal documents, other than the advance directive. I promised that I would talk a little bit about probate, and I've got just a few minutes to do that. Probate is kind of the most misunderstood practice. Everybody wants to avoid it. Probate in Alabama is not a difficult process for the most part. Now, there may be difficult families that make the process difficult, but it's not the process that's making it difficult, it's the family that's making it difficult. The probate process is easy and straightforward in Alabama. The probate process is simply the process that you use to prove a will. When you die, if you've done it correctly, there's going to be a piece of paper that says it's your last will and testament. You're going to have signed, it's going to be witnessed, it's going to be notarized. Nobody knows that that is really the document you did. You're not there to tell them that that's your document. So if you've got an account down at XYZ Bank, the executor or personal representative of your will can't take this piece of paper down there to XYZ Bank and say, look, this will gives me the money, I want you to write me the check. Well, how does the bank know that somebody else won't show up tomorrow with a piece of paper that says, look, this will, he died 2 days ago and this will gives me that money. Why did you give it to that guy that showed up yesterday? His document was fake. So in order to protect the holder of these assets, the will has to be authenticated, and that's what the probate process does. When you admit a will into probate, everybody who would have inherited had that will not existed is given notice. And they can raise any objection that they have. Oh, that's not Daddy's will. Oh, I don't like that. I don't like it is not an objection to a will, just so you know. He didn't mean to leave me out is not an objection to a will. There's only certain objections you can raise to a will, and he mistreated me is not an objection. So that's all that probate is. It's not some scary, awful process that the court's trying to take over everything you own. It is simply an authenticating process to prove a will. That's what it's for. Do all wills have to be probated? In order to be valid, they do. Now, why do I say it that way? It's possible that you could pass away and none of your assets are going to be controlled or governed by the terms of your will. If you've deeded your property to your children, reserving a life estate, and all of your bank accounts have beneficiaries on them, pay on death beneficiaries, and that's all you own when you die, then the property automatically becomes your children's property. The accounts are going to pay to the beneficiaries, so the will doesn't control anything. If it doesn't control anything, it doesn't have to be probated. Does that make sense? The reverse of that is true. You can't have your daughter's name on all your bank accounts and then your will say, I leave my accounts to my 3 children. If your daughter's name's on there, those are your daughter's accounts when you die. So it is extraordinarily important that all of your beneficiary designations and your ownership are consistent with what your will says. And for any of you who have minor children, disabled children, anybody who is a minor or disabled person that you're including in your estate plan, you never want to leave assets directly to a minor or a disabled person. You want to leave it either in a trust or some other custodial fashion for that person. Met with some folks today. They want to leave assets to a 9-year-old. I said, well, you shouldn't name your 9-year-old as a beneficiary on your life insurance. Oh, well, then I'll name her dad. Well, if you name her dad gets the check, which kind of defeats the purpose of you leaving it for the 9-year-old. So we talked that through, and what they really want to do is create a trust for their 9-year-old with the dad in control of that trust to manage it for her, where it's her money. He's managing it, but it's her asset. Okay?
If you have like a durable power of attorney, that expires after death, right?
Good question. Durable power of attorney expires with you. So your power of attorney dies with you. The minute you die, there's no more authority under that power of attorney. It's a good
You could,
question.
if you had it, you could take the money out of the CD before somebody died. But if you waited until after they died, you couldn't.
Yeah, if the bank knows they're deceased, yeah, I'm not even going to go there because that's fraud. Yes, real quickly, question.
Could you address someone recommending a bank to be a trustee? I haven't found that to be a really good idea. It's very expensive and it has so much control and it can never be changed.
The question is about corporate trustees. Should banks be trustees? In certain families, absolutely, we need corporate trustees. If you've got poor money managers in your family, if you've got family who don't get along, I'm not in favor of putting one sibling in charge of another. You don't want one sibling to be a banker for another sibling, particularly if there's mental illness involved. So there are certain situations where we definitely need corporate trustees. Real quickly, I got time for about one more.
Who has to present a will for authentication to the probate judge?
It's a good question. Who presents the will to the probate court? Any interested party can. Normally, it's the personal representative of the will, whoever's in charge of the will, to be named the executor or personal representative. But
It's a paper issued by the probate judge saying it's authentic?
once a will is admitted into probate, the court has accepted it as the true and correct will, then the court issues what's called letters testamentary to the person in charge of the will. Alabama calls that person a personal representative. So they are issued a document from the court saying, yes, you are in charge, you are empowered now to go collect the assets of the estate.
Does he have to be sworn in the state?
Does the personal
He's in
representative
state.
have to be sworn in? No.
Okay. He's out of state?
I have no idea. I only am licensed in Alabama.
You mentioned the will. Can you quickly mention something about the living trust?
Living trusts are great for some people. They're not the best thing since sliced bread. So if you want a living trust, it is something that you have to keep up with over your lifetime. It's not like a will where you do it, put it in the drawer, and forget about it. Y'all going to bear with me just 1 second, and I'm going to read my poem that I always read at the end. For those of you who are new to my presentation, there's this delightful poem called Warning. It's by Jenny Joseph, and it's kind of what I aspire to as I age. When I am an old woman and I shall wear purple with a red hat which doesn't go and doesn't suit me, and I shall spend my pension on brandy and summer gloves and satin sandals and say we've no money for butter. I shall sit down on the pavement when I'm tired and gobble up samples in shops and press alarm bells and run my stick along the public railings and make up for the sobriety of my youth. I shall go out in my slippers in the rain and pick flowers in other people's gardens and learn to spit. You can wear terrible shirts and grow more fat and eat 3 pounds of sausages at a go, or only bread and pickles for a week, and hoard pens and pencils and beer mats and things in boxes. But now we must have clothes that keep us dry and pay our rent and not swear in the street and set a good example for the children. We must have friends to dinner and read the papers. But maybe I ought to practice a little now, so people who know me are not too shocked and surprised when suddenly I'm old and start to wear purple. Thank you.
Mr. Price and Mr. Flowers and I were talking here today about a real hot topic, and that is what we're seeing on our highways with these lawyers that are advertising on these billboards, making fools of lawyers. That's what I say. And it's an opinion. The people that are doing it are lawyers and my friends, but I've got a real strong opinion about it. I have read, and all the studies show that the number one thing that people hate lawyers for and have the bad rap for is those foolish advertisements. And it embarrasses me every day. I know maybe you have. I'm sure, Phil, you've seen it a bunch where in my negotiations with the other side, my own clients will say, well, if we can't settle it right now, I'll just get a wreck and get a check or something.
533?
Yes. That's it.
I haven't seen any of them personally. I'm just kidding. When I first started practicing law, was right when they changed the rule to allow lawyer advertising. But it seems to have evolved. I mean, lawyers have a bad pitch anyway. We have a thing to overcome in terms of perception by the public. But I think advertising can be done in a responsible and ethical way. But it seems that the advertisements have gone way over to the edge, like any other thing, if you will, business, and my one comment would be it's obviously working to some extent because the number of dollars that you see spent, they've got to be getting cases in and turning it over and buying more advertising.
You know, and in our field, probably what we see more than anything else, and what Phil and I do is Phil and I do DUI defense, and it's criminal issues. And we actually do see that too in our field, and we hear about that also from clients. From what happens is you know, if a person gets arrested, then somebody is, you know, going through courthouse files and pulling up their personal information and sending them, you know, basically sending, they get a, you know, a virtual plethora of flyers. And, you know, in those situations, I think it's really, you know, it can be incredibly tacky because somebody's, you know, mother may not know about it, you know, somebody's family member. It's going to some address that's on a driver's license, you know, a spouse, you know, an ex-spouse, you know, a soon-to-be ex-spouse. I mean, so there's all sorts of issues that come in there, and I think I probably hear about it more along those lines than anything else.
Call that jail mail, or that's the name that's, they get the public records from each of the jail facilities, and then the lawyers will, and they said that this is ethical. I don't agree with it, but then that's your target market, and some lawyers get that target market, send a letter to their last known address on file with the courthouse, and send them a letter saying, hey, I'm out here, please come and hire me. I heard you got arrested.
What they're doing, if you get arrested, you get a letter in your home mailbox, and it opens up and says, please call us for your defense. We're real good lawyers. Yeah, I think it stinks, and like you say, your mother gets a hold of it or somebody else. And then when you see this on the highway, that just makes people look so foolish. What our discussions are with us plaintiff trial lawyers, the car wreck lawyers, which I do, is that we're seeing from the insurance companies, they're laughing at them because they know that those people don't try cases. They are not real trial lawyers. And what they're doing is they're settling. You got a $100,000 case, they'll settle it today for $60,000 because they know if they refer it on to real lawyers who try the case, they won't get as much money.